I think it's consistent in the comments I've quoted to you and your previous statements that you do believe that your backgrounds will affect the result in cases. And that's troubling me. So that is not impartiality.
As I've indicated, my record shows that at no point or time have I ever permitted my personal views or sympathies to influence an outcome of a case. In every case where I have identified a sympathy, I have articulated it and explained to the litigant why the law requires a different result.
Well, Judge,
I do not permit my sympathies, personal views, or prejudices to influence the outcome of my cases.
Well, you said something similar to that yesterday, that in each case I've applied the law to the facts at hand. But you've repeatedly made this statement, quote, I accept the proposition that a difference there will be by the presence of women and people of color on the bench, and that my experiences affect the facts I choose to see as a judge. First, that's troubling to me as a lawyer. When I present evidence, I expect the judge to hear and see all the evidence that gets presented. How is it appropriate for a judge ever to say that they will choose to see some facts and not others?
It's not a question of choosing to see some facts or another, Senator. Our life experiences do permit us to see some facts and understand them more easily than others. But judges do consider all of the arguments of litigants. I have. Most of my opinions, if not all of them, explain to parties why the law requires what it does.
Well, do you stand by your statement that my experiences affect the facts I choose to see?
No, sir, I don't stand by the understanding of that statement that I will ignore other facts or other experiences because I haven't had them. I do believe that life experiences are important to the process of judging. They help you to understand and listen, but that the law requires a result, and it will command you to the facts that are relevant to the disposition of the case.
When you look at the evaluation of the judges on the Second Circuit, you stand out like a sore thumb in terms of your temperament. What is your answer to these criticisms?
I do ask tough questions at oral argument.
Are you the only one that asks tough questions in oral argument?
No, not at all. The processes in the Second Circuit are different than in most other circuits across the country. And that some lawyers do find that our court, which is not just me, but our court generally is described as a hot bench. It's a term of art lawyers use. It means that they're peppered with questions. Lots of lawyers who are unfamiliar with the process in the Second Circuit find that tough bench difficult and challenging.
If I may interject, Judge, they find you difficult and challenging more than your colleagues. And the only reason I mention this is it stands out when you know, there are many positive things about you, and these hearings are designed to talk about the good and the bad. And I never liked appearing before a judge that I thought was a bully. It's hard enough being a lawyer, having your client there to begin with without the judge just beating you up for no good reason. Do you think you have a temperament problem?
No, sir. I can only talk about what I know about my relationship with the judges of my court and with the lawyers who appear regularly from our circuit. And I believe that my reputation is such that I ask the hard questions, but I do it evenly for both sides.
In fairness to you, there are plenty of statements in the record in support of you as a person that do not go down this line. But I would just suggest to you, for what it's worth, Judge, as you go forward here, that these statements about you are striking. They're not about your colleagues. You know, the 10-minute rule applies to everybody. and that, you know, obviously you've accomplished a lot in your life, but maybe these hearings are time for self-reflection. This is pretty tough stuff that you don't see from about other judges on the Second Circuit.